and they will be heard. God save the United States and this honorable court.
Good morning, everyone. Mr. Huron, if you would be so.
Morning, judges. Good morning, counsel. The first case up this morning is 19-2211, Advantageous Community versus King. Counsel, please prepare to argue.
Counsel, good morning. We're ready to hear you.
Good morning, Your Honors. This is Stephen Sanders, LLC, Arminder Carr, and plaintiffs Harsapal Singh and Harachi Singh.
And this is Daniel Dolan, Your Honors, arguing for the 7 former state employees, including Gary King and 6 others, one of whom was never served in this case.
All right.
May it please the court?
We're ready to hear you.
All right. This case is about the malicious prosecution and continued prosecution through the use of fraudulent documents by the state of New Mexico, by its employees, because you can't sue the state under Section 1983. And it's about qualified immunity, and it's about whether enough discovery has been allowed by the district court in before deciding motions for summary judgment. In September of 2009, the state of New Mexico, through the New Mexico Attorney General's office, brought suit against Advantageous under the New Mexico Medicaid Fraud Act. The basis of that suit was that some of the Medicare providers, Medicaid providers, had not had a previous criminal background check, and that therefore any billings by those providers were ipso facto fraudulent. The state took no actions to determine whether or not any of those individuals had in fact a criminal background. They didn't. The state used documents that were, the criminal background check was supposed to be done before the people started their work. During the course of the litigation, the state manufactured documents, which they should have had in their file the original criminal background check or a copy of the original background check before filing a lawsuit and saying that no criminal background check had been timely or at all ever completed on any of these employees.
What are the specific facts that give rise to the assertion that the exhibits were fraudulent?
Well, the specific facts that give rise to that assertion were actually found in, this was a state district court case by the state district court, and the state district judge found, and that's prominent in our brief, and I'll just read you a little bit of it, that the clearance letters used by one of the state employees.
Please don't read to us. Just tell us. Just tell us. Okay.
Well, the state district court found that the state investigator and other people that were named as defendants in this case actually created documents to show when the clearance letter was in their files, which is a necessary element.
So the documents were made up out of whole cloth, or the documents were modified to show, the date of filing or other essential elements. Which was it?
I would say it was the latter, Your Honor. They weren't made up out of whole cloth, but they didn't have the documents, so they had to make it up based upon their computer, which put different governor, different addressee, different dates on these documents. These are documents that are essential to their prosecution because they're alleging there was no timely criminal background check. And so the state district court, as a sanction for using fraud and false evidence, dismissed the case. Also determined that motion for summary judgment was warranted because the state had no evidence to support its case. And so that's the genesis of this particular action. We allege that for probable cause to bring a lawsuit under even the narrow civil standard, that you got to have if you're the state and you're saying something didn't happen and we have a copy of it, we didn't have a copy of it. The state didn't have a copy of it. And therefore it was just a wholly made up prosecution. Not only that, but
let me interrupt for a minute. Advantageous was sued by the state, but the individual plaintiffs in this case, they're plaintiffs in this case, were not sued. How can they bring a malicious prosecution case when they weren't part of the prosecution at all?
I would say that the individuals couldn't bring the malicious prosecution case, but they can bring a violation of their liberty interest because during the course of the litigation, instead of waiting for it to be over, the state terminated the contracts with Advantageous at several years into the litigation. It wasn't just an immediate thing that was going on. Their names were maligned as using false evidence. In fact, the New Mexico Court of Appeals said it's really ironic that the state of New Mexico was accusing these people of using false, of not having false criminal background checks or not having the criminal background checks, and yet the state was using false documents to prove its case.
In looking at your support for the damage to their reputation, we look to the complaint, don't we?
Exactly, because it was a motion to dismiss.
I see lots of arguments in the briefs, but I don't see much in the complaint that gives much detail about the damage to the reputation. And, we've got 2 newspaper articles. It says 3, but in my copy at least, one of them's in there twice, the same article. But if you look at those articles, they don't even name the individual plaintiffs. And they actually are very negative towards the state about the case. So I have a hard time seeing how that is damage to reputation. Can you enlighten me?
Yes, ma'am. What I would say is that this is a small community. The providers of Medicaid services to the state of New Mexico, when the state brought lawsuit against Advantageous, there are only 3 people there that would be involved in managing and operating Advantageous, and it was known throughout the community that those were the 3 that were accused of falsifying voucher requests to the state of Mexico for reimbursement.
Counsel, did I understand your answer to Judge McHugh that there is no malicious prosecution claim against the individuals?
By the individual. By the
individual.
A violation of their liberty, due process interest, and having their reputation.
No, I understand, but they aren't involved then in the malicious prosecution claim.
No, just only Advantageous would be involved in a malicious prosecution, Your Honor.
I have a couple of questions about the malicious prosecution claim. The district court said there isn't clearly established law that withholding of Medicaid reimbursement is a seizure. Do you agree with that?
What they did was they actually went back and withheld from currently.
No. I'm asking about the law. Is the law clearly established or isn't it? I'm not asking what happened. I'm asking about the district court's holding that there's no clearly established law. Do you agree with that?
I don't agree with that.
Okay, and where did you say that and cite authority in your brief to that effect?
Well, the Mexico Court of Appeals ruled that you could not withhold money based upon this claim under the New Mexico rules and regulations for Medicaid and the federal rules, and that's New Mexico Court of Appeals, and the district court held the same thing a couple of years before that those regulations were not a basis. And we have 2 prongs of malicious prosecution. It's not only that the lawsuit legally had no factual basis, had no legal basis, but had no factual basis because they didn't have the document in their file to provide to say this is when or a criminal background check was performed or never was performed.
Let me just
both the
ask
legal
you,
theory and the factual.
Counsel, let me just ask you another question. And I'm asking you this question in the context of qualified, has this court ever recognized that there can be a Fourth Amendment malicious prosecution based on seizure of property?
Your Honor, I'm sorry, I can't answer that. I don't know.
But don't you need to have authority that there can be such a cause of action?
No, sir. I think under the due process clause of the 14th Amendment, that a person has a right to be secure in their person and property with notice and an opportunity to be heard prior to the seizure. And I would like to reserve the rest of my time, if I could, for rebuttal.
Reserved.
Your Honors, let me answer a couple of questions that Mr. Sanders glossed over here. They're very, very important. May it please the court, it's important to note that the documents that Mr. Sanders is talking about were actually documents that were contained in an Excel spreadsheet. The state doesn't have the ability to save tens of thousands of copies of letters that are sent out on a routine basis by the Department of Health or Human Services Department of the state of New Mexico. And so what they did was they kept the data, the names of the people, the dates, and the content of the information in an Excel spreadsheet. The investigator for the Attorney General's office went to the Health and Human Services Department, and they printed those using the Excel spreadsheet. They were not copies of original letters. And so when the administration changed, the letterhead changed. And I would point out that the letterhead still has the State of New Mexico seal, State of New Mexico, and over on the left-hand side in small type is the new governor's name. The attorney for the state of New Mexico, the Assistant Attorney General at the time, when these documents were printed, which I would point out was well over a year after the suit was brought by the Assistant Attorney General for the state of New Mexico, David Hughes, that gentleman did a 15-month investigation after having a referral from the Human Services Department and found that there are violations of the Medicaid Fraud Act, and that the provider, Advantageous Community Services, had failed to provide the documentation required under the contract that they signed with the Human Services Division, saying that the providers that they had the criminal background history checks in place. In other words, it was the duty under the contract for Advantageous to provide the state with the required notice. And under the Medicaid Fraud Act, the individual—
Counsel, given that that would be a technical violation of the contract, how does that become fraud for the billing? Were the services actually provided as asserted? In other words, is the fraud based purely on this, what I will call technicality for our purposes, or was it a broader assertion of fraud than that in and of itself?
Well, it was a broader assertion, Your Honor, and the reason I say that is because in the deposition of David Hughes, the attorney who actually filed this case and did the 15 months worth of investigation, he noted that, and I point out, it's really important to note that the letters that Mr. Sanders and Advantageous point out as the basis for the allegation of maliciousness by the state didn't even exist. They were actually printed more than a year later by the investigator as the case was going forward by Assistant Attorney General David Hughes, and then later by Assistant Attorney General Landau. So the investigation actually showed that they had not provided the letters. And so
I understand. But my question is, let's say that's correct in terms of the violation of the contract, but is that the sole assertion of fraud, or were the services in fact not provided?
In fact, Your Honor, the services may have been provided. The Department of Health was finding in analyzing the work and hearing and discussing the complaints against Advantageous at the Department of Health level that Advantageous had missed appointments. Advantageous had employees that had not met the qualifications required for these respite services, because these are the most vulnerable people in the Medicaid process, people who absolutely have no way of determining whether or not they're being abused. And so those complaints, along with the fact that Advantageous had not produced the letters to the state under the contract, and that they had violated some of the other provisions of the contract, which are basically that they had proper training, that they vetted their people, they missed appointments. That's why the lawsuit was brought. There were 15 months, actually 3.75 years of time when negotiations went on between counsel for Advantageous and the state of New Mexico to settle this case. And it wasn't filed. It was actually begun to be investigated in 2006. It wasn't filed until 2009 by Assistant Attorney General David Hughes.
Counsel,
so there were more adequate activities by Advantageous that required under the Federal Health and Human Services Department was vetting and looking over the shoulder of the state of New Mexico because of Medicaid fraud, and New Mexico was under the gun to continue to maintain its own Medicaid programs, and Health and Human Services was saying, you're not doing an adequate job, and that's why that lawsuit was brought.
Counsel, as to your point that the action was initiated before these documents were emerged during the discovery process, how do you respond to Advantageous's argument that once the altered letters did surface, that the action was that the state continued the action because they chose to appeal the dismissal of the enforcement action? This is the continuation argument as opposed to the initiation argument.
Yes, Your Honor. Let me back up just a little bit. Judge Euling held an evidentiary hearing, and at that evidentiary hearing, she found that the counsel for the state of New Mexico had failed to recognize the administration change on the letterhead. She was upset that they were trying to be used in a deposition. And I would point out that the Assistant Attorney General for the state of New Mexico immediately withdrew those letters, never referred to them again. The plaintiff's counsel brought this to Judge Euling, and Judge Euling, because of the power of the state, obviously, in bringing these kinds of cases, dismissed the case outright against Advantageous. The state felt that was an unusually harsh action by the district court judge, state district court judge, and in fact, appeal was really basically went to the Court of Appeals to say, Court of Appeals, what we would rather see is we'll throw this evidence out. We'll prove the violation of the Medicaid Fraud Act by actual testimony of the people who drafted the letters. And certainly those people were still working at that time for state government. They could have been brought on and testify in the words about that letter being drafted and sent to Advantageous. So there was ample evidence available for the case to continue and for those letters to be thrown out. As a matter of fact, they were never, ever referred to again by state counsel. They were obviously thrown away and recognized as being printed from an Excel spreadsheet that was improperly used because of the new administration. So the evidence was still there. Assistant Attorney General David Hughes and Assistant Attorney General Landau both still had ample evidence of the malfeasance of Advantageous, and they appealed basically the decision to throw the case out. They wanted the case to continue, and they would produce the evidence in a different manner, not using the documents, because they could use direct testimony. The evidence was still there.
Let me interrupt you because it's hard to get a question in. The other argument is that at the very latest, you should have known there was no basis for the lawsuit when the decision in behavioral home care came out, which rejected the whole basis for your fraud claim.
Yes, Your Honor. But if you look at the dates of those cases, behavioral health in the underlying case in the Mexico district was decided after the case was brought against Advantageous. And so that case was appealed separately to the New Mexico Court of Appeals. And that appeal was up at the New Mexico Court of Appeals when the state of New Mexico was appealing the state district court judge's dismissal of their case. That actual appeal, those appeals were almost parallel, but the decision in behavioral health that would impact the case that the state was bringing against Advantageous was actually decided a month after, I believe it was 3 weeks actually, after the Advantageous cannot settled law in New Mexico. You could bill for services provided by a respite care provider. So it only became settled law a month after the decision by the New Mexico Court of Appeals that Advantageous, affirming the trial judge's dismissal at the evidentiary hearing of the case against Advantageous. So it didn't exist. The law was unsettled. As a matter of fact, Judge Fashing, our district court judge here in this case, in her findings of fact in the summary judgment motion order, basically stated that this was a novel issue, that it was an issue of first impression, and that it occurred a month after the case affirming Judge Euling's ruling against the state was actually heard. So it wasn't settled law in New Mexico. The state had ample opportunity to continue its case, and the evidence was still there and available by the use of individuals to prove that the criminal history background check documents were not filed in a proper manner in compliance with the Medicaid Fraud Act.
Counsel, did the district on the discovery issue, the Rule 56D issue, by failing to take proper account of the declaration that was filed in support of the motion?
Your Honor, I think that is really a false argument. If one looks at the actual docket filings in the federal court case, you'll see that the Advantageous filed a letter 3 days before the summary judgment motion was actually decided by the federal district court judge. During that time period, we filed our motion for summary judgment almost a year before Judge Fashing ruled that we were granted summary judgment. During that entire year, plus all the months that were prior to that time period, Advantageous was given more than 20,000 pages of documents. As former employees, the state employees that I was defending had no access to the state's computers, no access to their files. We were given a thumb drive with the documents that we turned over with the privilege log to Advantageous.
The judge granted the motion for additional discovery, and that just additional discovery period was still open when the district court judge granted the summary judgment, right? Issued the summary judgment, right?
That's correct. That's correct. They had that 12 months from January until December, plus at least another 12 months prior to that to conduct discovery. They didn't even issue third-party discovery subpoenas until late in that last 12-month period. they issued.
But they
subpoenas
had an
again.
extension until December of 2019, right?
That's correct, Your Honor.
So they weren't out of time. They could have still done that, but for the ruling that cut off the discovery period that had been granted by the magistrate. I mean, it's a little confusing in the record what happened because the district court doesn't even mention the magistrate's discovery, and despite your thumb drive with all the documents on it of the
Advantageous case, the dismissal or the affirmance of the summary defense. So there wasn't anything. There was nothing left. And the district
counsel,
court,
please answer the question, but be aware almost 2 minutes so far.
Yes, Your Honor. I'm done. Thank you.
Well, Judge McHugh may not.
No, I'm finished. Thank you.
Thank you. Judge Matheson, questions?
For me.
You're excused. Then we'll hear from your colleague here.
Thank you, Your Honor. Starting on that last thing, that the declaration that was submitted in support of the motion on the Rule 56F identified that there were depositions that had refused to cooperate in declaration. It mentioned that there were huge gaps in the numbers. It wasn't just, okay, we got 20,000 documents, that's all you get. There were, of those 20,000, there were big gaps without any justification as to why there were gaps. There was a lot of information that was requested that the magistrate had ordered, and the defendants didn't comply with the order. They were ordered to give an affidavit that the only thing withheld was attorney-client privilege. They didn't even give such an affidavit until 30 days after it was past due, and then with those huge gaps, some of which it was easy to see provided to third parties. So attorney-client, there was quite a bit that needed to be done before the decision should have been made. As far as the Excel spreadsheet that was first mentioned, created from the Excel spreadsheet, these are fundamental, found their case that there wasn't a criminal background check. They should have had those in their file. As far as the argument that there were other things that Advantageous did that were improper, such as not showing up for appointments, that didn't make it into either the district court decision or the Court of Appeals decision. Was based not only on the sanction, but on the district court found they didn't have any evidence of any of their allegations, or if there was more than one, and granted summary judgment. And the Court of Appeals affirmed that and affirmed the sanctions. One of my points is,
as you argue, it occurs to me, why aren't we merely relitigating issues that have already been litigated at court level?
I think that's a good point. I think the state court made the decision that in fact, the Court of Appeals said it was particularly egregious that the state of New Mexico was falsifying documents. That's the foundational requirement, and that's foundational to our.
No, but what I'm asking is, are the issues that you're arguing to us, were they originally presented to the New Mexico state courts?
No, sir. What was presented in Mexico state courts was that there was no evidence. Now, on our side,
just a jurisdictional issue arose in my mind during the course of your argument that, what are we doing in the federal courts relitigating issues that were presented to the state courts? There are several doctrines.
States should be foreclosed from arguing or errors on the thing, and they weren't reused. They were, in fact, reused all the way to the Court of Appeals. But ours is a damage case. That was a defense case. It wasn't a counterclaim in the other case. Maybe there could have been for malicious abuse of process, but there wasn't. Also, I don't think you can sue under a Mexico tort law for malicious abuse of process, the state, unless it's a police officer. So there were other technical difficulties. I could say more, but I see my time is basically up, and I really appreciate the opportunity to argue before you.
Thank you, counsel. We appreciate your arguments. The case is submitted. Counsel are excused, and Mr. Huron will call the next case.
Thank you, Judge. The next case this morning is 20-2018, Hendrickson versus AFSCME, Council 18. Counsel, please prepare to argue.
Morning, Your Honors.
Good morning.
Thank you. Brian Kelsey on behalf of Plaintiff Appellant Brett Hendrickson, and may it please the court. This case really turns on one sentence. To give your consent, you have to know what you're consenting to. To give your consent, you have to know what it is that you're consenting to. And in Janus versus AFSCME in 2018, the Supreme Court said that non-union members must give their affirmative consent to waive their constitutional right to pay nothing to the union. Hendrickson never did that. Instead, Hendrickson was given an unconstitutional choice between paying union dues or paying 87% of that amount.
Well, counsel, how was there any lack of consent or mutual mistake at the time the membership agreement 3 times, given that Abood was the governing law at that time?
Judge Matheson, that's a good question, and I think you're exactly right. The question is, at that time, did he give his affirmative consent? And the question is also, what did he give his affirmative consent to? He certainly gave his affirmative consent, given those circumstances, to have those union dues taken out. What he did not give is what is required by Janus, and that is a affirmative right to pay nothing to the union.
Now wait a minute, counsel. Why should he be able to void his membership post-Janus based on a change to the law that didn't make the contract itself illegal, but might have affected his decision to enter the contract in the first place?
Because that is the law of the circuit as well. Under the
what's your authority for that?
Yes, that is the U.S. versus Bunner case. Your
Say
Honor.
That again. U.S. v. what?
Versus Bunner, B-U-N-N-E-R.
All right.
And that's a 10th Circuit case from 1998. And in that case, it said that there was an intervening United States Supreme Court decision. And that stands for the proposition that that subsequent decision constitutes a mistake of law that allows the party to reopen that agreement to choose one option versus another. So
is this the plea agreement case?
It is.
Okay. And in that case, it frustrated the entire purpose of the plea agreement because the government traded a plea for one crime and dropped the other things in the indictment. And the whole point of it was to have him plead guilty to a crime. And once the court decided there was no crime at all, it completely frustrated the purpose of the contract. But here, it doesn't frustrate the purpose of the contract. He agreed, he entered into 3 times to be a member of the union and to have the benefits of that bargain. In the plea agreement case, the federal government and the defendant both lost what they were bargaining for. So I don't think that case helps you.
Well, I appreciate that view, Your Honor, but I think that the correct analogy in that case is between Hendrickson and the prosecutor. And in that case, it was the prosecutor who did voluntarily agree to not prosecute on those 3 other crimes, those 3 other causes of action.
In exchange for a guilty plea to another crime. So the benefit of his bargain was completely frustrated because what the defendant pleaded to was not a crime. Here, the benefit of the bargain, the contract, was I pay union dues, I get services from the union. Nothing about Janus speaks to a union member who voluntarily enters into a union contract. Nothing about Janus frustrates the purpose of that agreement.
Well, and I would respectfully say that the alternative in that Bunner case was ruled unconstitutional, just like in this case, the alternative was for Mr. Hendrickson was to pay 87% of union dues. That is no longer the alternative. The alternative that is the law of the land under Janus now is that he gets to pay $0 to the union.
But in Bunner, the intervening case invalidated the crime. Here, nothing about Janus speaks to whether someone who voluntarily becomes a member of a union, it doesn't invalidate that. It doesn't even speak to that. It only talks about charging dues to non-union members.
Your Honor, the union case, it does argue that Janus applies to non-union members, and that's because Janus himself was a non-member. But that's not all that the case says. It says, quote, employees must clearly and affirmatively give their consent. So the Janus decision applies to all government employees at the time that they're presented with the decision whether to join. And it's so from being a non-member to a member.
Counsel, let me just make sure if I'm understanding your argument correctly. If you turn the clock back to when Mr. Hendrickson signed his membership dues deduction authorization 3 times, if Janus had been decided at that time, it would have changed his calculus, I suppose. Is that your argument is he might have thought about joining the union differently? Is that basically your argument?
That's exactly the argument, Your Honor. Because
okay, and again, I'm just not understanding how the plea agreement cases get you there.
Well, those cases state that when an intervening U.S. Supreme Court decision rules that one of the 2 options is unconstitutional, then that bargain is reopened and you can choose the other option, and that agreement is foreclosed. Just like the prosecutor no longer had to stand by his agreement not to prosecute on the other 3 crimes. In this case, Mr. Hendrickson no longer has to stand by his decision to pay 100% of union dues. And in fact, the facts, we don't think it's necessary in our briefings, but the facts show that we actually pled coercion the first time that he signed his union card back in 2007. He had left the Department of Human Services. He had gone to a different department that was not covered by AFSCME. He came back to the Department of Human Services, and for 6 months, he did not pay a dime, even of agency fees. And if that is when the union approached him with this unconstitutional choice, he's of limited means as a state employee. He couldn't afford to pay the full 6 months of back agency fees at that time. He felt coerced into making the decision to choose to pay the full union dues at that time. And that is when the unconstitutional waiver to pay nothing was. So the Janus decision even says on this very point, it says, quote, by agreeing to pay, non-members are waiving their First Amendment rights, and such a waiver cannot be presumed. So that sentence cannot be talking about Janus himself because he never agreed to pay anything. It's talking about non-members like Hendrickson used to be back in 2007. And it says that when he does agree to pay, he can only do so by waiving his First Amendment right. And he's never been able to do that. That may be possible going forward, Your Honors, certainly. But it was at the time. By signing the agreement, which he did he become a union member? According to the laws that were in place at the time.
According to the agreement.
According to the terms of the agreement, which is unconstitutional now, yes, he did.
I understand your argument, but he became a union member. Had he been a union member prior to signing the agreement?
He had not, as is the case with all union members. They're not born union members. They have to become union members, and the Janus decision describes the criteria by which they become so.
Had he previously been a union member?
Originally, the Department of Human Services, when he was first hired, was actually not covered by a collective bargaining agreement. So he was not originally. In
previous years, had he been a union member?
He as I mentioned before, he started paying those union dues back then.
I don't want you to see me as hostile to you. I'm just trying to find out to understand your case, right, whether he had been a union member at any time prior to becoming a union member pursuant to the terms of this agreement.
Well, as Judge Matheson said, he signed the agreement. The first one, I believe, was back in 2007, and there were 2 subsequent agreements.
All right. So the answer is yes. He had, by virtue of those 2 previous agreements, he had been a member.
That's right, Your Honor, and that's why I'm harping on the 2007 decision.
And I'm harping on the language of the Supreme Court that talks about members and non-union members and trying to determine the status in which your client fits.
Right.
Thank you.
And again, I would say that I wouldn't say it. The Janus decision is very clear. It applies to employees. That's the word it uses. Employees must give affirmative consent.
An affirmative consent by employees when I sign an agreement that says I hereby join the union and authorize you to deduct union dues from my pay. I mean, isn't that an affirmative consent?
It is, Your Honor, an affirmative consent based on an unconstitutional choice that was given to him. And so with that, Your Honors, I would prefer to...
Counsel, I need to ask you another exclusive representation issue, and that is, this is your ability to sue the governor and the attorney general. The New Mexico Supreme Court has said that the PELRB must remain free from the executive's control or coercive influence. Doesn't that mean that the governor and the attorney general are not proper ex parte young parties, and that you should at least have sued members of the PELRB in addition to them?
Well, first of all, Your Honor, I just would like to point out that you are correct that the district court only applied this ex parte young analysis to the second claim for exclusive representation, yes, and not the first claim. That was not entirely clear from the briefing. But in that instance, the reason why the governor and the attorney general are the proper parties, because the issue is not whether the Public Employee Relations Board, Labor Relations Board, not whether those laws that they're applying, it's not whether they were being properly applied constitutional in the first place. And that's why under the case of Petrella versus Brownback from this court, of that statute is called into question.
So your time is reserved.
Thank you, Your Honor.
Thank you. All right. Counsel
Eileen Goldsmith for AFSCME Council 18. I'm sharing time with counsel for the state defendants, and I'll turn it over to them after 10 minutes.
All right.
So there are a great many issues that are addressed in the briefs and addressed just now, but the court really only needs to reach a few of them. First, there's no First Amendment infringement in giving effect to plaintiff's own authorization to pay dues, and any prospective relief claim in connection with that issue is moot. And second, exclusive representation collective bargaining does not infringe plaintiff's First Amendment rights, as every circuit to reach the issue is held, and as the Supreme Court held in Knight. But I want to take a step back because we're talking a bit about the facts here. Plaintiff never paid.
What distinguishes this case from Janus?
So Janus is about whether the state can, by operation of law, require people who have never joined the union, who have never authorized the payment of dues, can require those people to have money deducted from their paychecks to an opt-out system where their consent to those payments is presumed. And Janus has nothing to say about people who affirmatively decided to become union members and instructed their employer to deduct dues from their paycheck affirmatively.
Choice that was available to Mr. Hendrickson, or was it de facto essentially foisted upon him?
It was not foisted upon him at all. Both just in terms of looking at the summary judgment record, which we have as undisputed facts in this case, and as a matter of law. On him at every moment of his membership, which actually goes back to 2003 to 2004, he had the choice whether to be a union member or not. And plaintiff,
So it was not a term of condition of his employment that he be a union member.
That's correct. That's correct. He chose that. He actually, as the summary judgment record shows, he signed an authorization to have the union recognized as the exclusive representative of his bargaining unit with the state back in 2003. He signed his first union, quite an active member, as the record shows. and was in fact on the bargaining unit against this and continued to exercise his rights of membership. He signed a new counsel's comments about not in the summary judgment record, and should for that reason be disregarded. And he signed another authorization in 2017. And in exchange for those authorizations, he received those benefits of membership, which he in fact exercised. And
one other question, and that is, come December of, let's see, last year, I guess, did he opt out then of no longer being a union member?
Yes. So what he did was, the first time the union became aware that he wanted to resign his membership was when he filed this lawsuit. That was November 30th of 2018. And so
that would be 18.
2018.
So as of 18, he was no longer a union member.
Correct. As soon as he filed the lawsuit and the union became aware of his desire to resign membership and terminate his dues deductions, he was let out of membership and his dues deductions were terminated.
The effect of this, of anything we could do, would basically be to, at best, refund partial dues for 2018.
Yeah, plaintiff has his prayer for relief calls for a refund of dues paid to the union while he was a member, but he never paid any amount that he did not authorize. And so enforcing or giving effect to his authorization doesn't infringe any First Amendment right. It's the equivalent to the Supreme Court's holding in Cohen v. Coles Media. Parties can impose obligations upon themselves, and those obligations can be given effect without infringing the First Amendment rights. And it's just the same as the Ninth Circuit held in Belgao and the Third Circuit held in Fisher, which we submitted earlier this week, and in Oliver. And we would encourage the court to agree with the Ninth Circuit and the Third Circuit on these issues.
So, counsel, just to be clear on the timeline here, my understanding is that he did notify the state agency about withdrawing his AFSCME membership in August of 2018, but he continued to pay, or his dues continued to be deducted. Why wouldn't he be regarded as a non-member at that point and be able to recover those dues, just as non-members shouldn't, under Janus, have to pay the agency fee?
So he didn't actually attempt to resign his union membership in August of 2018. If you take a look at the record, Your Honor, and this is in the appellee's supplemental appendix at 110, what plaintiff August of 2018 was he sent an email to the state personnel office, and he said, when can full members resign and stop their dues deductions? And he didn't contact the union. That's undisputed fact in the summary judgment record. He didn't say, I want to resign and terminate my dues deductions right now. He said, when can full members terminate their dues deductions? And the state personnel office responded, in effect, full members can terminate their dues deductions in the December window period. The union heard nothing from plaintiff until he filed this lawsuit against the union several months later, which happened to be at the beginning of the window period when dues deductions could be terminated, and therefore they were terminated.
So do you argue mootness?
Yes. So plaintiff has raised, he's seeking to enjoin the future operation of the union's dues deduction agreements with respect to the revocation period. But this has zero effect on plaintiff because his dues deductions have already been terminated, and the only way they could ever resume is if he were to reauthorize those deductions and rejoin the union. And there's no realistic likelihood that the union could in any way seek to have the state take deductions from his wages. And his suggestion that there should be some kind of prospective relief because it might affect the world at large is just not at issue here, because this is a single plaintiff case. It's not a class action. The only person with any interest at stake here is plaintiff himself, and he has no realistic risk of any future harm.
How does Ex parte Young come into play?
I would like to defer that issue to the State's Counsel, if I may.
That's fine.
Yeah. And the only other point I wish to just briefly address before I turn it over to the state is this mistake of law question.
Well, you have 50 seconds to do so.
Okay. The more salient authority here is not Bunner. It is the Brady case, the Fisher case, and Belgau and Oliver. The issue in Bunner, which I think the court clearly understands, is that the bargain that the parties actually struck fell apart when the offense that plaintiff had pleaded to was no longer a crime. The difference with our case that makes it more like Brady is, or Koltek, Fisher, US v. Porter in this court, the difference here is that what the parties agreed to was lawful at the time, and it was complete at the time, and it continues to be so today. And with that, I'd like to turn it over to Mr. Marcus.
Thank you. Mr. Marcus?
Thank you, Your Honors. Larry Marcus on behalf of the state defendants or state appellees. So first off, I just want to say that the state appellees are fully aligned with the union regarding both the issue of the revocability period regarding the difference between this case and Janus, as well as the issue of the exclusive representation. So we're in alignment with the counsel for the union on that. But in addition, we are arguing that the state defendants are not the proper defendants. And Your Honor, you brought up Ex parte Young a minute ago. Ex parte Young, of course, is the exception to the 11th Amendment, which allows the bringing of a claim for prospective relief against the state official in his official capacity. However, in order for that exception to apply, that state official has to be able to do something, has to be able to take some action to provide some redress for the plaintiff's claimed grievances. And in this case, neither the governor nor the attorney general could actually take any, there's nothing that the court can order the governor or the attorney general to do regarding the exclusive representation. The exclusive representation is part of the PIBA, the Public Employees Bargaining Act, and the PIBA is not enforced by the governor or the attorney general. Most statutes would be enforced by the governor or the attorney general. So in most cases, if you're trying to declare a statute to be unconstitutional, it would be the governor and the attorney general that you would file a lawsuit to enjoin them from enforcing the statute that you believe to be unconstitutional. But in this case, the statute is not enforced by the governor or the attorney general. It's enforced by the Public Employees Labor Relations Board, the PELRB. And it is those individuals, it is those board members who, they're the ones who certify the exclusive representative. They're the ones who, they handle the negotiations. If there's a dispute regarding who the exclusive representative is, it's the PELRB that handles all of those issues. And
well, counsel, could you just address why isn't it enough to sue the governor under Ex parte Young, given that the governor appoints the members of the board and also is the elected official responsible for the New Mexico Human Services Department, which employed Mr. Hendrickson, and also the State Personnel Office, which or the New Mexico Human Services Department, which employed Mr. Hendrickson, and also the State Personnel Office, which, as I understand it, carries out the dues deduction through the payroll system. Why isn't that enough to bring the governor in?
Because the governor appoints the members of the PELRB. She does so under a very constrained system. One member is selected by the labor unions, one is selected by employers, by state agencies, and one is selected or other public employers, and the other is selected by the other two. And so the governor just sort of goes along with it. I don't want to say she's quite a rubber stamp. In many ways, she is in this case. And she absolutely cannot fire these individuals. These individuals serve a fixed term, and the governor has no firing ability. And this is by design to keep the board as a neutral arbiter between labor and management. And you can't have management having too much control over it. Otherwise, the whole system doesn't work. It's no longer neutral. And the PELR and the State Personnel Office and the Human Services Department, they weren't the ones who certified the AFSCME as the bargaining, as the exclusive representative for that bargaining unit. Yes, they do deduct the dues, but that's a strictly ministerial action, and they do that when the labor union gives them a list and tells them to deduct these dues. And they wouldn't otherwise even find out about it unless the labor union, they wouldn't even find out if someone withdrew unless the labor union told them. So all of these individuals in this regard, they're essentially rubber stamps here. And so they are not the proper defendants. They cannot be ordered to do anything that would change anything for the
well, they could be ordered not to deduct the dues.
In order not to deduct the dues for who, though? It would only be people who the labor union said are no longer members of the union. So you'd have to order the labor union not to provide these names to the Human Services Department. But once the names are, it's not the job of the Human Services Department or the State Personnel Office to figure out whether someone should have been a union earlier. That would not be within what they're legally authorized to do.
Mr. Marcus,
yes, sir.
Mr. Marcus, if I may, please. Judge Matheson, if I may as well. Is this action brought by Mr. Hendrickson collectively on behalf of others, or what's the nature of the representation?
No, Your Honor, it is not collective. He brought it on his own behalf.
Then why isn't this case moot?
It is moot. I think it's moot. I agree with you.
Has there been a jurisdictional motion on this case?
It was part of both the motion to dismiss and the motion for summary judgment in the
All right, thank you. Well, let's hear from your colleague, and if you'll add a minute and 19 seconds to his time, please, Mr.
Thank you very much, Your Honors.
Thank you. You may proceed, Mr. Kelsey.
Thank you very much, Your Honor. A couple of facts to clear up because they relate directly to your last mootness question. Just to go back, he started working for the state in 2001. His department unionized in 2003. Then he left, worked for another department. He did not join in 2003. He left, came back to work, and that's when the 2006-2007 issue that I mentioned regarding coercion came up. But the more important fact on mootness, Your Honor, is the fact about what he did in August of 2018. So this was now 2 months or a month and a half after the Janus decision, but before his 2-week escape window period came open in December of 2018.
Yes, but if Ms. Goldsmith is correct, and we have to join issue here on these points, because I just don't want to waste our time if this is a serious problem. She says that really it wasn't until December the time the open window had come into play that you did anything affirmatively to notify the defendants in this case that you didn't want to be a union member anymore, and that was the filing of your lawsuit. But by then, you could have elected not to be a member anyway under the open window of that was available to you. And I just don't see why the case isn't moved from the get-go.
Well, Your Honor, it's not moot
If you don't purport to bring this case on behalf of others.
That's correct, Your
Honor. Well, you don't do so in a representative capacity. You filed a lawsuit in your own name.
That's correct, Your Honor. And so back in August 2018, he sent one email, and in that email that you can read in the record, it references an earlier email, which neither party has anymore. But he notified his employer, who was the one who was actively taking the dues from his paycheck. And it was up to them to notify the union that they were stopping the deduction. They did not do that because they were following the New Mexico statute, which is still on the books today. So it is his claim for money damages.
Let me interrupt. I've got the email right in front of me, and there isn't any record evidence of a prior email, so we can only speculate to that. But he says, "Good afternoon, Sandy. I seem to have lost your response regarding full union members. Are we able to withdraw as full members now, or do we have to wait for a certain amount of time? Thank you ahead of time for your response." I mean, that's an inquiry. It's not I want to quit the union, stop deducting dues.
Because he had asked already that he had asked to stop deducting dues. But the answer that was given is very
No, it doesn't say that. It doesn't say I asked before to stop deducting dues. It says I seem to have lost your response regarding full union members. We have no idea what all we know is it was regarding full union members.
Well, respectfully, Your Honor, that's not the record on summary judgment. The record is that, as Ms. Goldsmith said, the record is that there was no direct communication made to the union, but no one has claimed in this case that he never requested to resign in August 2018 from the state. And that because of that money damages claim, that's why this statute is still not
be irrelevant whether anybody has claimed it. The point is that you have to have said, I want to quit. I want my money back. Your client didn't do that until this lawsuit was filed. And by then was really an academic exercise. He had the right to withdraw from the union as a matter of right under the terms of his contract, irrespective of anything that Janice may have said on the subject.
Well, the reason why I say it is relevant, Your Honor, is because it must be in the summary judgment record that they're disputing that fact that we have put into our First Amendment complaint, and that's not in there. So that's not moot because it's a claim for money damages, if I may finish this one point. And because of that claim for money damages, that is why wrapped into that, you necessarily have to make a decision as to whether New Mexico Statute 10-7E-17 is constitutional, which is the statute that allows for these escape window time periods. Thank you, Your Honor.
Thank you. Ms. Goldsmith, you're saved by the bell. You have 22 seconds. It's what your colleague here has run over, so you've got 22 seconds.
Thank you, Your Honor. I would just respond that the First Amended complaint allegations really wash out at this point because we have a summary judgment record, and I would encourage the court to look at the summary judgment record. Thank you. I have nothing further.
Thank you. Thank you very much. Thank you, counsel. The case is well argued. The case is submitted. Counsel are excused. And we'll take a third case before we take our break. So the next case is going to be called by Mr. Huron.
Thank you, Judge. Counsel, the next case this morning is 20-2022, Rio Grande Foundation versus City of Santa Fe, New Mexico.
Thank you.
Your Honor, thank you. May it please the court, my name is Tim Sandifer, appearing on behalf of the Rio Grande Foundation. On page 28 of the city's answer brief, they say any donor who does not want to appear in disclosure reports can choose not to contribute to ballot measure advocacy. I think that's a really interesting quotation because it really crystallizes what this case is about. If people want to exercise their First Amendment rights to speak on a political issue, they sacrifice their confidentiality. And if they don't want their names, their employers' identities, or other personal information put on a publicly accessible government list, they have to choose not to contribute to that political campaign. And the question before the court is it constitutional to force people to make that choice? This ordinance says anytime the organization spends $250 on an issue campaign, it has to give the government personal identifying information about anybody who contributed any money for that purpose, even just $10, $20, $5, even just a penny. And the test here is exacting scrutiny. And that means that there must be a sufficiently important government interest. The relationship between the burden imposed on speech and that interest must be a substantial one. And the city has to show that it can't serve that interest by any significantly less broad means. And
let me interrupt. So you would agree that it's a balancing test, right?
Yes, Your Honor.
It's a comparison. So even if we were to accept your argument that that it's a minimal interest rather than a substantial interest as found by the district court, we would still need evidence of burden. And as I read the district court, what it said is that you didn't provide any evidence whatsoever because you didn't provide any affidavit to any information, any evidence about members of the foundation who had been burdened by this. That what you did was you tried to rely on affidavits and testimony from people in other organizations. I think the district court has a good point there, and so I'm very interested in what your response is, which I'm sure you're going to talk about Buckley. So let's take that on.
Yes, Your Honor. Well, so Buckley does say that in a challenge like this, a plaintiff can demonstrate this risk of retaliation, intimidation, or threats by testimony or other evidence relating to people with similar views who have...
But that's not what Buckley says. You quote Buckley and you leave out new parties that have no history upon which to draw may be able to offer evidence of reprisals or threats directed against individuals or organizations holding similar views. You're not a new party that has no history upon which to draw. Your organization's been around for 20 years and has been involved in a lot of initiative actions. So I'm struggling with whether there's anything to balance against whatever the interest of the state is.
I think there's two answers to that, Your Honor. The first one is it's undisputed that the foundation has never been required to provide this information prior to the enforcement that was at issue in the record. So until 2017, the foundation was never required to give out that information. And so in that sense, they are a new party in that they are newly required to provide this information. And secondly, I think that Buckley, we have to understand that Buckley makes clear that the reason why, and not just Buckley, but other chill cases, make clear that the reason why you can't require a plaintiff to show that they are personally harmed or retaliated against or intimidated or threatened is because it's impossible to prove today that you won't suffer retaliation tomorrow or a month from now or years from now. And that's why the test in a chilling case has always been an objective case. It's never been a subjective test. It's a test that determines whether a person of ordinary firmness would hesitate to speak out under these circumstances. And that can be proven by showing that similarly situated organizations and their supporters have been subjected to retaliation and so forth. Requiring the foundation itself to prove that it itself has been subject to threats or harassment or intimidation is a legally improper burden, and it's too high. And remember also that when we're talking about chilling effects, not only can you not prove today that your supporters won't be harassed next month or retaliated against next month, but it's also possible that the retaliation or harassment in the future might be over a different issue. The organization might place this information on a publicly accessible list today, and then 5 years from now, take a position that's a controversial political position that nobody had ever thought of 5 years before. And
let me interrupt. All of these are interesting arguments, and I don't remember reading any of these in your brief. I don't remember anywhere in your briefs where you argued that we are essentially a new party as recognized in Buckley because of the changes that you've just mentioned.
Well, I think you're right. We get into. I'm sorry, Aaron. I think we get into this issue when we talk about whether the district court imposed an improper evidentiary burden on the plaintiffs by forcing us to prove that we ourselves have been harmed. And Your Honor's question was, why does Buckley cover that? And the answer to that is that there are several legal reasons, as well as policy reasons, why courts do not require that kind of evidence when talking about a chill burden. And we do talk about this, I know, in the supplemental brief on standing as well. So I do think it is proper for us to make the showing that this is a significant burden by showing that other similar organizations have suffered this kind of harassment. And also remember, it's not a particularly difficult burden for us to show that a person of ordinary firmness would hesitate to contribute to or speak out on an issue, knowing that this information is going to get out there. But our focus in this case is really primarily about interest and not about the burden, although, you know, obviously.
But you need both. I mean, even if the interest is a feather, you have to have something to put on the other side of the scale.
Yes, that's right, Your Honor.
And if the district court is correct and you cannot rely on information based on what's happened to other organizations, then there's nothing to put on the other side of the scale.
Well, I think, Your Honor, it's undisputed that this does impose at least some burden. I mean, there is a non-zero burden in having to prepare these reports, submit them, and subject oneself to this kind of publicity. And if the interest is sufficiently lightweight, then even such a small burden would still be excessive. And our view is that the interest here is just that lightweight. The Sampson case really provides us the best guide in that. And what Sampson says, Your Honor asked earlier about a balancing test, Sampson says we're talking about a spectrum here. On one hand, you've got the kind of rule that says the major sponsor of an initiative has to put that information out there, and that's a strong informational interest. On the other end of that spectrum, the court says there's minimal interests, such as in Sampson. Now in Sampson, remember the thresholds were $250 spending, you have to report anybody who's contributed $20. And here, it's relatively the same. It's $250 spending and $0.01 contribution. And what is the interest according to the Sampson analysis? Sampson points out the Supreme Court's never endorsed the informational interest at all in issue campaigns to begin with. You run a real risk of an ad hominem problem where the voters focus only on who funds. Third, the court says that the informational interest varies with the dollar amount. The public doesn't really have an interest in knowing.
Counsel, let me just interject. You mentioned your standing brief a few minutes ago. I need to get some clarification on. It seems as if your brief is saying that the alleged injury is that the ordinance grants associational rights with its donors. Is that what your alleged injury is?
Yes, Your Honor. It's the burden of threats, retaliation, and intimidation, both against the foundation and its donors, and that incidentally is what differentiates this.
But it's an injury. It's an injury to the organization, correct? Not injury to your. You're not arguing on behalf of your donors.
I believe we're making both arguments, Your Honor. We're contending that our donors want to contribute to us in knowing that their information will be kept confidential and that we will inflict injury on them when we're compelled to disclose that information.
What is your allegation or what is your evidence that on a Santa Fe ballot measure? I mean, you're only asking for perspective that happened in damages for anything that happened in 2017.
Right. So, well, Judge Matheson, I'm going to go off video for 1 second here, but I'm listening in, so don't worry.
Okay. Where's your injury? Where's your standing injury in fact that supports your claim for prospective relief?
I think, Your Honor, that it's undisputed between the parties, and also that the district court found that the foundation has been around for 20 years, is well known as participating in these kinds of public debates, that it will speak out when incidents arise where there's an initiative or something that touches on its interests. And those interests were all found to be sufficient to give standing in the Walker case.
Well, the parties can agree to standing that we have to take seriously, and I'm just not seeing any kind of imminent risk is out there that the ordinance is going to be enforced against you again. Where is that in the record or in the allegations?
Well, your foundation not only has participated, but does continue to participate in these kinds of political disputes. And it's really, there's no question that the foundation is subject to this ordinance. It has been subjected to it in the past. And that's really all that's required to bring a case for prospective relief, is to show a likelihood that you will be subjected to this the objectionable statute that you're challenging. The court found that the Institute for Initiatives and Referendums had standing to challenge requirements that applied to initiatives and referendums without necessarily showing any particular campaign that it intended to participate in. I did want to say a word about the city's facial versus as applied argument. They seem to be of the view that we can only do an as applied challenge to this ordinance instead of a facial challenge. And I think that's a little confusing, because that relies, it appears, on a misunderstanding of what Citizens United said. Citizens United, remember, was a candidate speech case. And in that case, the court said that these kinds of disclosure requirements are constitutional in that context. And consequently, that left parties with only as applied challenges in the future. But this is an issue campaign context, and so that language doesn't really apply here. And I would direct the court to the Supreme Court of New Mexico case that we cite in our supplemental reply brief on standing, the United States versus Supreme Court of New Mexico, where there's a very helpful discussion of facial versus as applied. And the court makes clear that, of course, you can bring an as applied challenge a facial challenge to a law that applies even to just a narrowly defined group such as attorneys. And finally, I wanted to say, before my time, I want to take a little bit for rebuttal. So I did want to say, with regard to chill, remember, we're not talking about subjective chill here. There is an objective chill, which is that the foundation, and this is in the record, the foundation spent $1,500 on postcards to distribute to voters, urging them to vote no on the soda tax, which it chose not to send out, but to discard as a consequence of the enforcement of this ordinance. So if the court is concerned that we're sounding like I think the city calls it a theoretical possibility of chill, this case has as objective a chill as the court could ask for. I'd like to reserve the remaining time for rebuttal if there are no questions.
Reserved.
Good morning.
Good morning.
And may it please the court, I am Tara Malloy. I am representing Appellee, City of Santa Fe, and the city's Ethics and Campaign Review Board. I think we, of course, take a completely counter position to RGF, and the basic argument is that the district court properly applied exacting scrutiny to this case. It followed exactly what this circuit's precedents direct. First, the district court noted the important governmental interests supporting Santa Fe's disclosure law, the important its strength, and then it balanced this interest against the actual burdens alleged by the plaintiff here, RGF, and found that the interests outweighed the burdens. This is precisely the mode of analysis that this circuit has instructed the courts to engage in, and it also complies with Supreme Court precedent. RGF.
Let me interrupt you there. In determining that it was a substantial interest, did the district court acknowledge that for a ballot initiative, we're only looking at one of the prongs of the justification for the interest?
Absolutely, Your Honor.
And in assessing that, what about the sliding scale approach? Did the district court consider all of the factors that we have suggested go into the assessment of how great the interest is?
Yes, Your Honor, the district court did. The district court noted and discussed at length this circuit's precedents in Sampson and Williams, and noted that this circuit has found that the strength of the governmental interest does vary up and down with the amounts spent in terms of its analysis in those cases. However, the overarching point is that when arguing that the city has no strong or substantial governmental interest in the law here, RGF picks the wrong target. It is not looking at its own level of expenditures in city elections, which were at least $7,500, if not closer to $10,000. Instead, it targets only the disclosure threshold of where Sampson and Williams looked at specific expenditures of particular plaintiffs. It declined to rule on the facial validity of Colorado's issue committee political, just said that, this law very well could be applied constitutionally to larger expenditures or more sophisticated groups, but this is not the case here. And we are going to look at specific expenditures in that case.
Sampson and Coalition, this statute was different in some respects because there were very onerous registration requirements. And one of the considerations was that they were so onerous that the average person couldn't figure out how to comply with them without going out and hiring an attorney and an accountant to do all the work necessary. I mean, we don't have that here, do we?
Absolutely not. And now we're looking at the burden side of the ledger. And as this panel has already indicated, there seems to be no evidence offered by RGF, and the district court found no evidence offered by RGF of the actual burdens on RGF because of operation of 9.2.6. It did not show any donor loss. It did not even indicate that any donors had ever requested anonymity. It had no allegations of harassment suffered by its own donors, staff, or officers. The district court just found that there was nothing to substantiate its general allegation of possible donor chill. And
counsel's arguing that we really are new. As Buckley says, you know, when you're talking about a new organization, you may be able to borrow information from other established organizations. And they're saying that this statute didn't apply to us until I think he said 2017, and therefore, for all intents and like a new organization, because we don't have operational history under this statute that we could rely upon. How do you respond to that?
Well, certainly this was not an argument that RGF has ever presented in the course of this litigation. That said, Buckley provided that only new parties can appropriately provide evidence of different groups. And it did not turn on whether the new party had operated under a legal regime or not. It was simply whether or not they could show some sort of experience with public hostility or some sort of experience of very closely affiliated groups with public hostility in order to substantiate their claim that there is a reasonable probability of harassment and reprisals if their donors. The best answer to that comes from Citizens United, which also looked at that plaintiff's claim for Buckley's as-applied exemption for harassment. Citizens United, like RGF, was a fairly established advocacy group. They did not offer any evidence that their own donors or staff had at any point been chilled. Instead, it only offered evidence of different groups and how their donors had been blacklisted, threatened, and otherwise targeted for retaliation. But the court found that this was insufficient. It noted exactly what the district court did here, that Citizens United had offered no evidence that its members may face similar threats of reprisals. And the best evidence of Citizens United's potential danger was its own long experience.
Counsel, if I may change the topic just a touch, do you read the complaint here as seeking only prospective relief?
RGF has clarified at multiple points that it is only seeking prospective relief.
Then let's talk about standing then. How can there possibly be standing from, I know your view is that there isn't, but how can there be standing on the as-applied claim if the relief is only prospective?
Well, right. That is exactly what the city tried to explain in its supplemental briefing. I would note that RGF's case seems to have evolved considerably throughout the course of this litigation. In the district court, the city understood and the district court understood the plaintiffs to be bringing an overbreadth challenge, which would allow it to step beyond the facts of its own case, step beyond its own activities to challenge a law on the basis of its potentially impermissible application to other plaintiffs. It has disavowed such a theory and in fact somehow claims that the fact that the district court analyzed it according to this theory at all after applying the substantial relation test is somehow an error of law, which the city disputes. But given the evolution of this case and the fact that now it is simply claiming that it seeks a remedy as to its prospective activities while providing no explanation of those prospective activities, it does seem that there is not a sufficient injury to provide the factual basis for an as-applied ruling. The city pointed to case law from the Fifth Circuit and the 11th Circuit where there are similar challenges brought by plaintiffs that claimed that thresholds of disclosure laws were too low. And the city said, look, maybe even if you pass bare standing, you have alleged nothing with specificity in terms of your future activities. How can we possibly craft an as-applied ruling with the particularity that that type of relief requires. And
now you don't argue on the as applied challenge that they're standing for that purpose.
The district court and the city, by necessity, have analyzed the as-applied challenge on the basis of RGF's almost $10,000 of expenditures in the 2017 soda tax ballot measure election. That's the only point of reference that the city had. So that is what the district court, the law was constitutional as applied to that level of expenditure. And of course, it was very unlike the situations of the plaintiffs in Sampson and Williams.
But purely on the inquiry of standing for the facial challenge, that you don't challenge that.
Well, what we designate as RGF's broadest facial request, which is, as it alleged in the complaint, that the court should strike down 9.2.6 on its face with respect to all covered city ballot measure advocacy.
But is that a standing issue, or?
Well, insofar as
I'm trying to ask about standing to challenge the facial validity as to whether there's an issue on that point from your perspective.
The city did not contest RGF standing in terms of the broad.
Thank you. That's the question I was asking, and appreciate all the rest of the information. Thank you.
Thank you.
Just as a follow-up, counsel, on that, do you agree that courts need to be more lenient on the standing issue when the alleged injury is First Amendment chill?
I think that it's fair to say that courts are fairly lenient in terms of the standard for standing in First Amendment cases. And then again, as I was trying to clarify in response to the earlier line of questions, insofar as RGF is alleging that the statute is unconstitutional in all applications with respect to ballot measure advocacy, well, it has alleged it's going to do ballot measure advocacy in the future. So presumably, if the statute is struck down in its entirety, it will not apply. It may have standing.
But counsel, isn't there still a question of alleging injury or alleging imminent risk of injury, even on the facial claim?
Well, I think that it's a fair point, and I guess officially the city takes no position on RGF standing with respect to the broadest facial claim. Its own chosen standard under initiative and referendum required not only the plaintiff to allege a law had applied to it in the past, but that it would continue to engage in such activity, even if it wasn't particularly specific in terms of the factual allegations as to that activity. But what the prong that RGF seems not to have met is to suggest that the law is actually going to prevent it or from speaking in the future. The one bit of evidence that RGF has offered is the affidavit of its president, Paul Gessig. And in that affidavit, the president states that RGF fully intends to participate in the future and does not appear to be dissuaded from participating in future ballot measure election by operation.
Counsel, I'm looking at that affidavit, and that's all it says. It doesn't say anything specific. They will speak in the future.
Correct. I think we're in heated agreement. The city did question in the supplemental briefing whether RGF had met that third prong of initiative and referendum, which is that it had not indicated that it was going to stop ballot measure advocacy, and thus it did not seem to be chilled in terms of its activities, even in the most bare sense.
Anything else?
Nothing further, thank you.
Thank you, counsel. All right. Mr. Sander, I think you have some time left. Yes, 1 minute and 26 seconds here. Go ahead.
Thank you, Your Honor. The city keeps trying to make this into an as-applied challenge when this is a facial challenge, and we could not have been clearer in our briefs that this is a facial challenge to this law. And as a result, this talk about as-applied exemptions under this point, we have no.
All right. So just to come to closure on that, then, this case really is about the facial challenge.
That's right, Your Honor. And we are not required to prove that we sought anonymity or anything like that. For one thing, the burden is on the city, not on us. Now, with regard to
standing, on improving standing, the burden is on the city to prove your standing?
No, Your Honor. The burden is on the city to demonstrate the constitutionality of this law, and that means that we are not required to show that we sought anonymity, which is what the city said during its argument. We are also not required to show that we ourselves have stopped speaking. The test for chill is whether a reasonable person would do so. Even a person who continues to speak in light of the risk of intimidation, threats, or backlash still can bring a chill speech in the appropriate case. So our standing is predicated on the fact, and you heard the city concede this fact, that we have spoken long in the past, we continue to do so, and will continue to do so, and will be subjected to this ordinance, and that is all the standing requires of us.
Thank you, counsel. We understand the case. It's submitted. Counsel are excused. The court will take a somewhere between 8 and 10 minute recess. We'll set it at 8. Oh.
Circuit. Judge Lucero, I just want to make sure you may have frozen. I just want to make sure that you can hear us. Actually, it looks like he dropped off, so we may need to take a moment for him to reconnect.
Okay.
Case this morning is 20-2054, Britton versus Keller. Counsel, please prepare to argue.
Counsel, we're ready to hear you.
Good morning, judges. This is Blair Dunn on behalf of the appellant Marcy Britton, and may it please the court. I would offer first an acknowledgement to the court that on its face, this may appear to be a somewhat bizarre case. But I will offer to the court that really what we're dealing with is a fairly run-of-the-mill takings claim brought in light of the recent Supreme Court's decision in Nix versus Township of Scott, Pennsylvania, along the lines that state remedies no longer need be exhausted. And so this is a first post-Nix appeal of a municipal program or ordinance that acts to inversely condemn a person's private property for the public benefit. And I don't think that that's any different than the majority of the case law that exists and is available to establish that this isn't anything other than that type of a run-of-the-mill case. I would first like to start by discussing where I think the district court first went awry. It's well settled and fairly bright line that when it comes to a takings case, and in this case, we haven't even established in the factual record for the court whether it is a physical invasion by the government or it is a regulatory taking. And the reason that
well, I actually had a question on that. What's your argument? You're not arguing that it's a per se taking, that she's been completely economically beneficial use of her property, are you?
No, that's correct. What we are arguing is that there is a physical instrumentality that the city of Albuquerque really doesn't have a whole lot of control over once they've dumped them. So it would be hard to say that it is this per se taking, but that's not necessarily something that has yet been established in the case. We do believe that the district court erred by jumping ahead and in basically engaging in a Penn Central balancing analysis before there had been a proper factual development of the record. This was a motion.
But counsel, on a motion to dismiss, doesn't the complaint nonetheless still need to allege facts to establish a plausible claim? You seem to be arguing that, well, we need to take discovery and flesh all this out. Maybe I understand that, but the complaint needs to stand on its own, doesn't it?
It does, Your Honor. It does, and
so the theory of your complaint is what? Back to Judge McHugh's question, do we have a physical invasion taking alleged here or a regulatory taking?
I think that it's I believe that this is a regulatory taking that arrives from a physical invasion through an instrumentality of the government. So the closest case that I would compare it to is the Arkansas Game and Fish Commission case that we discussed extensively in our briefing. Essentially, what you have is a policy in the government that they do not want to kill these cats. And so instead of killing the cats, they take custody or control of them. They may perform vaccinations and spaying and neutering on the animal, and then they take and they dump it. They abandon it out into the open. Our argument is that dumping of the cat that is in the custody and control of the state of the city of Albuquerque, dumping it out onto the land, essentially, so that it flows just as water would out onto the property of the plaintiff and then damages the property of the plaintiff is other than its water and cats, very akin to the U.S. Supreme Court decision in the Arkansas Game and Fish case. And we do believe that there has been a taking under that analysis from the United States Supreme Court. They have essentially dumped that out there. Whether it fits cleanly into a regulatory taking that's just a deprivation of a value of the property sufficient to do a Penn Central balancing, or it's an actual physical invasion, those don't fit clearly into this type of a case. It's more akin to the flooding case that we have in Arkansas. The next major point that I will turn to is this idea that somehow, because it's not, cats have never been used to effectuate the inverse condemnation before, that's not clearly established. That flies in the face of pretty much all takings law across the country. That's never always quite exactly the same, that the government is somehow decided through some sort of nuisance or trespass to do something that interferes with somebody's property, they do it pursuant to their decision as a government entity and a policy decision. The idea that it has to be exactly the same to be clearly established, as the district court seemed to fall into and has been argued by the appellees, I think that was the next big error. So to afford qualified immunity to the city of Albuquerque in this instance, again, I don't think.
Well, counsel, just to be clear, the qualified immunity part of this case relates to the individual defendants, correct?
The district court's decision isn't quite that clear. The district court
does a municipality receive qualified immunity under 1983 law?
Against the individuals because it is a 1983 claim. But I don't think that the district court was, I guess what I was trying to say is that the district court didn't divide it up and say that we didn't clearly establish that these defendants took some sort of action. We actually have quite a bit of allegations, very plausible allegations in the complaint that the individuals were engaged in some activity to take ownership of what has happened to Ms. Britton and her property.
Well, as far as the mayor, Mayor Keller and Director Navarez are concerned, the deed personal involvement, have you waived that issue by not arguing it on appeal?
I'm not certain that we waived that argument on appeal, Your Honor. I do believe that we did reference, I'm believing in my opening brief, we do reference that we cite to the complaint as discussing the phone calls between Mayor Keller and the plaintiff and her phone calls to Director Navarez. So we did actually have facts in the complaint, and I do believe I did address those in the opening brief.
I don't recall that you addressed this specific issue that the district court ruled on, which was the lack of personal involvement. You may have given a recitation in your fact statement, but I don't recall that you ever engaged on that argument.
It may not have been as clear as it was in my mind, but I may be in error. I apologize to the court if I am, but I do believe we did discuss that it was, and I think it was more in terms of the pleading standards. We argued that we couldn't really establish those facts without some amount of discovery, and at this stage in the pleadings, again, we had not had the chance to get to that point. We had alleged it in the complaint, so I think that what I was referencing is it's more found in the 12b6 discussion in our opening brief, that we didn't have the opportunity because we didn't get to the proper place in the pleadings or in the briefing in this case for addressing that on a factual basis. Again, getting to the point that the district court really
Counsel Judge Lucero, it seems to me that your claim here is really against the city for its program. Now, is the program pursuant to an ordinance?
I'm sorry if that was a question, Your Honor. It's pursuant to...
Yes, the question is the program conducted pursuant to an ordinance?
I believe it's conducted pursuant to an administrative instruction or a policy. It is pursuant to direction from the mayor and the city.
Right, yes, but did they adopt an ordinance providing the parameters of the enforcement of the policy?
I don't believe they did, Your Honor.
So it's just purely a policy.
Right.
It's directed by the mayor. Now, these employees don't have any discretion in the exercise of the policy, do they, in the implementation of the policy?
We're not sure, Your Honor. That's part of what we don't yet understand and what we couldn't address with the district court without the opportunity to at least engage in some amount of discovery, which we never got to do, to ask, in reality, Mr. Navarez if he had been afforded that direct discretion, or ask the mayor if he'd been affording Mr. Navarez that discretion to do that. We do know that Mr. Navarez was supervised by the mayor and by the chief administrative officer for the city, and that ultimately somebody in that food chain did decide that this was the policy and that they were going to implement it, and they did in fact carry that out. And it is a carryover policy.
Well, you're not asserting that these employees are going off at a frolic of their own, in which they are executing what you describe as the policy, and that by virtue of their own discretion, are you?
No, Your Honor. We're alleging that these are individuals that are acting under the color of the policy or the color of the law.
All right. So in response to Judge Matheson's question, because I didn't hear an answer to his question, is a qualified immunity doesn't apply to the city itself, does it?
No, the qualified immunity applies to the individuals.
Thank you.
Let me ask you this. If we view this as an exercise of the police powers of the city, and we also were to determine that there was a valid justification for the city's action in exercising its police power, would you have a claim?
Yes, Your Honor, if it's a valid exercise of the police powers. And that's where the substantive law in New Mexico turns on that point. And we did point that out to the district court. It's really highlighted, I think, very clearly in our reply brief. We discussed there's two state statutes at issue that place the city's actions beyond being lawful. One is that they're engaged in they've taken custody of these animals and then they are dumping them in violation of the state statute that makes that a criminal penalty. And then there's another one where it says that if a person has an animal under their custody or control and they allow that vicious, and the legislature actually uses the example of feral cats, to be loose and potentially able to harm somebody, that's also a violation of law. So there's two violations of law, so it cannot be a lawful action by the city to engage in this action. And if the court doesn't—
Counsel, how do you get around the Mountain States legal foundation decision?
I believe, as we pointed out in our briefing, and we referenced the Colvin case and the Fellini case as an example. We're not necessarily arguing that the animals per se are the offending action, and there is a distinction there. You're talking about wild horses that are not in the custody or control in the Mountain States legal case versus feral cats that are actually held in possession in the hands of the city as at one point. And there's a big distinction between those two. And then the city takes an action to release that animal. And that gets to our discussion about these feral cats are not typically under the law considered wild animals, whereas wild horses in Mountain States Legal Foundation were very much considered a wild animal. They are considered that by statute. So there's a big distinction between those two cases, purely on the type of the color of the horse, as it were, in this situation.
Well, but would you agree that the loss here or the damage you're claiming is incidental to the exercise of the police power? They picked up these cats in a location, they neutered them and vaccinated them, and then dropped them off on the same location. They didn't drop them off on your client's property. And so to the extent some of those cats wander onto the property, isn't that incidental to what the city did?
Not in the scope and severity of how it was accomplished. We're talking about establishing cat colonies in some instances with hundreds of cats adjacent to these people's property. It's inevitable that these cats are going to go onto that property and that person's going to bear the burden for them. So it's not really incidental. It's the same as if you open the floodgates onto somebody's property, as they did in the Arkansas Game and Fish case. If you dump that water out, it's going to go out and harm that person's property. That's inevitable. And if the court doesn't have any immediate questions, I'll reserve the minute and 20 I have left.
So done.
Good morning, Your Honors. This is Kevin Morrow on behalf of Tim Keller, Danny Navarez, and the City of Albuquerque with the appellees, and may it please the court. Certainly, based on the 12B6 that was granted by the district court, the city is of belief that was properly granted, and we ask this court to affirm the decision of the lower court. We don't believe that Ms. Britton has a colorable argument for a taking, whether it be per se or regulatory, that the city's actions do not infringe on Ms. Britton's enjoyment of her property. The city is not alleged to have physically entered the property. The or to have restricted what Ms. Britton can do with her property. As to Mr. Dunn's assertion that this is analogous to the case with Arkansas, we would dispute that, in that the factual predicate for that is that a dam was released and water, as we know, flows downhill. It was predictable, it happened repeatedly, and it happened every time that water was released from the dam. That is not the same as releasing feral cats back into the same area where feral cats already existed. As we all know, it is considered quite difficult to herd cats. And so the idea that it is both inevitable and derivative of the city's actions, and that the actions of the cats in walking across Ms. Britton's property is an instrumentality of the city, we believe it to be incorrect.
But counsel, isn't this case also different from Wild Horses and Mountain States Legal Foundation, in that feral cats in Albuquerque are not naturally occurring wild animals?
Well, I would dispute that to some extent. They are not defined by federal act as wild horses and burros as they were in the case you mentioned. However, feral cats are existing in the community. They exist. They are a problem. They do affect the public safety and welfare, which is to Ms. Britton's point. That is in fact the entire existence of this trap, neuter, and release program, is to mitigate what we recognize to be a public health issue. The capture of feral cats and the neutering and vaccination of them is directly designed to mitigate a health issue for the population. And
the New Mexico statute, once you capture them and perform these veterinary services on them, does that change their status so they're no longer wild?
It does not, because under, if you, hang on, my apologies. I believe it's under 77-111, which is the state statute regarding a municipality's ability to deal with animals at large. The only provision that is prohibited in that regard is that the city is prohibited from doing anything that would violate statute 77-1B et sec. And the city's institution of this trap, neuter, release policy is in no way prohibited. In fact, to one of Ms. Britton's arguments, it's implicit by emphasizing that the city has introduced a no-kill program, that the city would be allowed, and was previously allowed, to operate a euthanasia program. That is actually what is specifically allowed under 77-1B. Certainly, the government can capture and euthanize animals as a means to remedy the public safety. But the people at large would certainly be subject to animal cruelty statutes if they were rounding up cats and then executing in their own property. So there is a distinction between what the government is allowed, and I think that's what hinges on the existence of the trap, neuter, and release program.
Well, counsel, whether the feral cats are wild animals or not, the point at which they come into your custody, at that point, they're under the control of the city, correct?
I would argue that they're under the temporary control of the city, that they are.
Well, fine. They're fine. They're in temporary control. Let's not argue about it. The point is they're under some control of the city. And if in fact you're having colonies of 100, as many as 100 cats, this is not some minor problem. This is a major problem in a metropolitan area. The city has to adopt policies that are not going to create the kind of problems that are complained of here. What obligation does the city have, if any? Do you contend you have none? You can just release them back out into the wild, as it were?
Your Honor, actually, we would argue that the existence of the trap, neuter, release program is designed exactly to fulfill that obligation. And
well, it seems to me your policy is to make them live a little longer by protecting them from disease by inoculating them. And then you neuter them so that they can't reproduce, which I don't know how that affects their life cycle one way or another, but it seems to me that that's not doing anything to control the problem.
Well, I would contend that it actually does do something to control the problem, and that the ultimate purpose of it is to reduce the community cat population by reducing their proclivity to procreate. In this instance, bringing cats that are already in the existing area and then reducing their ability to procreate and then re-releasing them into the same area is directly, to your point, the city's attempts to mitigate this issue.
Well, counsel, related to that, if we accept Ms. Britton's allegations in the complaint as true, that the program causes disease to her family and property damage from defecation and urination amounting to a nuisance, how can the injury here be incidental?
Well, what I would argue is that the program doesn't create the issue of feral cats. The cats exist, whether the city were to capture them, neuter them, and release them or not. The existence of the program is actually to offset and mitigate the claimed damages of Ms. Britton. So its entire intent is to create a healthier community and to be a valid exercise of police power as we endeavor to create that healthier community. So beyond that, I wanted to touch on the issue of qualified immunity. I think the district court was correct in inserting that Ms. Britton did not make any direct allegations of participation by the mayor, Mr. Keller, or by Danny Navarez, the director of animal welfare. They are not alleged to have personally captured cats, neutered cats, released cats. They're not alleged to have stepped foot on Ms. Britton's property. And therefore, they certainly are not alleged to have done anything specific that could put them on notice that they would have violated Ms. Britton's constitutional rights. Additionally, Ms. Britton does not cite to anything that would indicate or make them aware that they could be found to have violated Ms. Britton's civil rights.
The argument in response is that we couldn't allege it yet because we need discovery. We haven't had an opportunity to find out who did what when. What's your response to that?
And I understand that is the allegation. I would say that, to your point, I don't believe that Ms. Britton alleged much in the brief to deliver anything with specificity. Additionally, even at the various level, making a few phone calls to Ms. Britton, I don't believe rises to any kind of constitutional duty, or the potential that they violated any of Ms. Britton's rights. Also, as we talk to, I think it's important to realize that the city's program does not affect or prohibit Ms. Britton from any particular actions. As has been mentioned, is the Fellini case, where it was mentioned that you cannot charge the horses with violation of the rights. However, what was really found was that the government actions prohibited the Fellinis from, quote, shooing away the horses. Ms. Britton is not prohibited in any way from building a fence, getting a dog, shooing away cats, anything whatsoever. The government has not prohibited anything that related to her individual actions, and therefore have not violated her constitutional rights. So I don't believe that the Fellini case is applicable in this matter, because I think ultimately the instrumentality that is alleged is the cats themselves, which the Fellini case said was not something that you could fixate on. So ultimately, I think I'd really just like to emphasize that the district court made an appropriate decision, that the motion was well-founded and well-heard, and that we agreed entirely with the district court's order. And I'd stand for further questions, but I think that otherwise I would use the rest of my time.
Well, are there any questions? I hear none, then we accept the ceding of your remaining time. We're ready to hear from your colleague.
Thank you, Your Honor. Very briefly, I think it bears touching on the questions that Your Honor asked about what could or should the city be doing. And that does get to the point that they had a policy in place that was in line with their statutorily charged duties to control the running of animals at large within the city limits. They're given that police power for a reason, and there's a responsibility that comes with it. Now, they have said that in they're attempting to mitigate the nuisance population of these cats by doing the vaccinations and the sterilizations. But the problem is that the way that they used to handle this was euthanasia, and that did handle the problem, and it did eliminate the nuisance issue in a permanent fashion. They enacted a policy to say we are no longer going to euthanize feral cats that come into the custody of the city of Albuquerque. That policy then turned around and placed the burden of supporting these cats, even after they've been vaccinated and sterilized, on the communities in which these colonies of cats are dumped and therefore established.
Well, does it matter if the cats were there before they were picked up to be sterilized?
I don't think it does. I think what's more important is the fact that the city takes custody of control, and then they go out and they abandon these animals without providing everything necessary for the animal to survive. And they place the burden on the community to house and to feed these cats. Otherwise, people have to watch. And that's a fairly inhumane way to handle an animal. You just dump it out there and hope that it makes it. It subjects them to being run over. It subjects them to depredation of other protected species under the Endangered Species Act. They starve to death. All kinds of horrible things happen to these animals. And that's part of the problem here, is that you're forcing the community to witness all these unpleasant things, or come out of their pocket to build their own fences, as was said, to keep the city's problem off of their property. And it's pursuant to the city's policy that this happened. And that's why it's a taking. And my time has expired. If there are no further questions, I appreciate the courtesy and the time of the court today.
Thank you, counsel. The case is submitted. Counsel are excused. Mr. Huron will call the next case.
Thank you, Judge. Counsel, the next case this morning is 20-2066, Santa Fe Alliance versus City of Santa Fe. Please prepare to argue.
May it please the court. I'm Teresa Kraft for the appellants. The plaintiffs alleged and expert affidavits supported that the TCA, the Telecommunications Act, specifically Section 704, denies them their constitutional rights to life, liberty, and property. Plaintiffs have suffered seizures, cancer, heart damage, loss of homes, loss of businesses from cell towers and antennas. The life-threatening injuries continue. The defendant's interpretation of Section 704, that the definition of environmental effects includes health, goes against the plain meaning of both words and, we believe, congressional intent. Defendant's implementation of 704 as preemptive of all state remedies are violations of the plaintiff's First, Fifth, and 14th Amendments. In enacting the WCAIIA and Chapter 27 as amended in concert with Section 704, the defendants have violated the plaintiff's First and 14th Amendment right to petition the government for redress. Additionally, WCAIIA and Chapter 27 as amended are an unconstitutional taking. The plaintiffs in their brief to the court have argued just that. The district court erred in ruling that plaintiffs had failed to state constitutional claims. The district court found that they had standing to bring the case, but then the district court said that they had failed to state a claim. We believe this was an error.
Let me just ask you about a couple of questions about standing. Didn't the district court say that you lacked standing to bring a claim alleging a violation of Section 704, but that you did have standing to bring your constitutional claims against the United States? Is that accurate?
Yes, that is accurate. And the plaintiff's position is that they never asked for remedies directly from the TCA, so the standing issue was non-relevant.
All right, so that's how you would distinguish the statutory claim versus the constitutional claim. But you're challenging, you're bringing constitutional challenges against Section 704, the state statute, the WCAII, 2 city ordinances, and 3 executive proclamations. Suppose we agree with you that one or more of these provisions are unconstitutional. How do we know that the city's decisions about locating cell towers would be any different?
What we know is that plaintiffs would be given opportunities to petition their councilman, petition the state for state tort claims. They would be allowed to seek remedies. It doesn't mean that they will succeed, but they will at least be allowed to do so.
Well, weren't they allowed to testify at zoning hearings anyway? In fact, they participated quite actively, didn't they?
They participated, but it was always under the shadow of 704's preemptive powers and 704's prohibition on considering environmental effects and the definition that environmental effects include health. Now, the U.S. has again raised the issue of standing in their papers. However, the plaintiff's opinion is that they are not in a position to raise standing because they did not cross appeal. They cite to a
Let me stop you right there. Even if they don't cross appeal, and even if they needed to cross appeal on this issue, which I don't think they do, we have to review our own jurisdiction irrespective of what you all do. So you don't waive an argument that there's no standing, meaning there's no jurisdiction, by not filing a cross appeal.
Yes. However, the cases that the U.S. cited to dealt with jurisdiction under diversity claims. And, anything under that vein dealt directly with whether or not the original court or the appellate court had the jurisdiction because of diversity.
Well, counsel, along the same lines, this court isn't restricted from looking at any applicable authority addressing standing, whether the government or any party has raised it. Wouldn't you agree with that? We're back to Judge McHugh's point that the court has a responsibility to determine whether it has jurisdiction.
Yes, the court has a responsibility.
So does it really matter which cases? I suppose if the cases were helpful, we could talk about them, but If we find something else applicable, there would be no restriction on our ability to look at those cases, correct?
Correct. Okay. So the WCIAA is the legislation that removes all restrictions on land zoning. And plaintiff's position is that by removing that, they no longer have notice, knowledge, and the opportunity to participate in the process of determining whether or not cell towers or antennas should be placed, where they should be placed, and how many should be grouped together. The Chapter 27, as amended, removed any type of application necessary, which again removed the notice component. So plaintiffs are in a position that they do not have an opportunity to redress this issue or file grievances because they're not given notice of when this is going to happen because of 27 as amended and WCIAA. Now, the plaintiffs have recognized that constitutionality, determining that laws are unconstitutional, is something that is to be avoided if possible. And the authority that we've cited would give the court the opportunity to do just that in determining that environmental effects does not mean health. There's no congressional authority that supports that Congress intended environmental effects to include health. There's the FCC doesn't speak of health.
Well, let me interrupt you there. By adopting regulations under the statute of what the limit is for the radiation from such towers, what is the level that is safe for humans, isn't it implicit that they see it as part of the responsibility to look at human health?
I don't think they do, and I don't think they did. I think that they've developed levels because they were required to do so. But in a recent case that the FCC was joined in, they did a really nice circular argument in saying that we don't have to state that something is safe level. We, as long as we've approved the equipment, it's safe. It doesn't matter. And honestly, this case is not about levels. The plaintiffs have not brought any claims against, what could be considered an appropriate level or an inappropriate level or an injurious level or a non-injurious level. Their complaints have nothing to do with levels.
Well, the argument that you're making, your concern is for the health of humans who are in proximity to these towers, right?
Correct.
And the FCC has made a determination that there's a level at which they are safe for humans.
I believe the FCC has determined that there might be a level, but plaintiffs are not arguing that. Plaintiffs are arguing that they have already sustained injuries and that with the placement of 5G small cells, the injury will become impossible to avoid. The further injury will become impossible to avoid. They will not be able to go anywhere and not be injured by this due to the design of 5G cells. It doesn't matter what the emission level is. It's the fact
Counsel,
that it's there.
is your challenge here only to 5G technology, or is it broader than that?
The challenge is not to fight the technology. The challenge is to accept that there have been injuries, and because there have been injuries, petitioners are due redressability.
Well, your proceedings under 12B here, so we take the pleadings as true.
Correct.
For the purposes of our analysis, and but the ordinance on the placement of these towers relates primarily at this point to the 5G technology, doesn't it? I mean, or unless there's other applications going on in the Santa Fe area that I'm generally unaware of in terms of American cities.
The proposed placement or expansion of 5G in Santa Fe does create a very big concern. However, that does not mean that this case would only provide remedies for 5G emissions or cell towers and antennas.
Right. So 704 speaks more broadly to the issue than merely 5G.
Yes. Absolutely, because 704 prohibits any state or local government from considering the environmental effects when awarding whatever they're going to use to award the telecommunications facility permission to provide those antennas and towers. By removing the definition of environmental effects, including health, is an issue. And I see that my time is up. I apologize. If there are any more questions, I'll be happy to answer.
I did have a quick question.
Sure.
Is there, do you assert that the word environmental is ambiguous to the extent that you need to look at congressional history to determine whether health was included? And is there anything in the legislative history that is helpful on this point?
We conclude that the plain meaning of environment and the plain meaning of health is enough for you to determine that. Congressional history, there was one point in which there was a House Commerce Committee report that was issued that talked about health. This was back in 2004, I believe. That talked about health, but it talked about health in the sense that the telecommunications would allow for people to participate in things more easily through internet and through phone. And that they said might, be beneficial to the public health, the public safety, things of that nature. At no time has has Congress said, you know, environmental includes health.
Thank you.
Thank you.
Your Honors, and may it please the court, Jack Starcher on behalf of the United States. The three defendants here plan to divide up our 15 minutes. I'll start by taking 9 minutes, followed by the city of Santa Fe with 4 minutes, and then the state of New Mexico with the final 2 minutes. Plaintiffs in this case allege that they have suffered various harms as a result of radio frequency emissions. They allege that those radio frequency emissions are produced by cell phone towers that are owned, operated, installed by third-party telecommunications companies, and that the decisions about where to place and whether to place those cell phone towers were made by the city of Santa Fe. At no point in that story does the United States or Section 704 of the Telecommunications Act come into play. There's no serious...
Oh, counsel, Judge Lucero, I cannot understand that argument, because doesn't the precise language of 704 say that the city cannot take into consideration environmental factors in the location of the towers?
That's correct. Section
so
704.
So if the tower is going up next to one of the homes of the plaintiffs, now assuming the factual allegations of the complaint to be true under 12B again, it just seems to me that the government can't say, well, gee, the statutes play no role, the code plays no role in the location, when in fact a citizen would be muted from being able to express any objection based upon environmental considerations to the placement of a tower right next to their house.
So two responses to that, Your Honor. The first of which is there's no question in this case that Section 704 does not dictate or mandate the result of any cell phone siting decision in particular. So even though it removes one factor from consideration, declaring Section 704 to be unconstitutional would not necessarily result in any particular placement decision coming out a different way, because it merely removes one factor from consideration. There are all sorts of reasons why a city or local government might choose to site or not site a cell phone tower in a particular location. The second response I guess I'd give to that point is that I think it's important to keep in mind the facts that have been alleged in this case. And while perhaps there might be another case in the future that presents a closer question on standing, the allegations in this case make very clear that the primary thing that is preventing plaintiffs here from expressing their views about radio frequency emissions is not Section 704 at all, but is these ordinances that they are challenging, as plaintiffs clearly allege in their complaint, and this is at JA 12, which is from the amended complaint. They allege that the city has repealed all notice requirements and all means of public participation in decisions about where to site these cell phone towers. And so, given the allegations in this case, plaintiffs have made it pretty clear, in fact, that Section 704 is not what is preventing them from expressing their views. And I'd go further and say, not only is Section 704 not preventing them from expressing their views on these topics, plaintiffs also made very clear in their amended complaint that they have, in fact, been expressing their views on these health topics at every opportunity. And so the idea that there's, this is what the district court, the basis on which the district court found standing was on this theory of some constitutional injury, a chilling type injury, as being the injury that is caused by Section 704 in this case. But that theory that sort of a chilling injury is enough to give plaintiffs standing here runs into first a doctrinal problem, I'd say, which is the Supreme Court's holding in Clapper pretty clearly states that mere allegations of subjective chill are not enough to establish standing to challenge some statute, absent some past objective harm that has been suffered. And then I guess my second point related to that one is there is no objective evidence of any sort of harm or chill in this case. Plaintiffs, again, looking at the allegations contained in the amended complaint, this is JA 26, paragraph 40 of the amended complaint. Plaintiffs plainly alleged that they have, in fact, participated in every approval process and have testified to their injuries and losses at every public hearing for every proposed telecommunications ordinance and every proposed telecommunications facility in Santa Fe from 2005 until the present day. So any suggestion that there has, in fact, been any chilling here is sort of foreclosed by plaintiff's own allegations. And so for all of those reasons, again, putting aside whether or not there might be a future case that presents a closer question as to whether or not Section 704 is a cause or the cause or a but-for cause of some injury, this case, the facts of this case, I think pretty clearly show that Section 4 has sort of nothing to do with.
Isn't the fact that the municipal governments are precluded from hearing or considering the arguments made in and of itself proof of a violation of the asserted right?
No, Your Honor.
In other words, it's akin to saying you can protest all you want, but we're going to place the tower wherever the utility wants it because we can't listen to your protests. You're saying that's not injury.
Sorry.
No, that's all right. Isn't that what you're arguing? But it seems to me from where I sit, and kind of where we stand in this business is where we sit, I guess. But from where I sit, and what I hear you saying is essentially that the mere fact that the municipality can't listen to the objection or can't consider the objection is not injury.
Yes, Your Honor, that's right. And unless there's some additional facts to suggest that there would have been a different outcome if those concerns had been raised. Again, to focus on what plaintiffs' injuries are here, plaintiffs' injuries in this case, they make clear, are related to specific siting decisions and radio frequency emissions emitted by specific cell phone towers. This is, there's a prior litigation brought by these plaintiffs challenging these ordinances that was dismissed for lack of standing because they hadn't identified this. They didn't appeal that decision, so there's not a decision from this court, but they hadn't identified specific cell phone towers that were causing them injury. They'd merely challenged sort of the existence of the ordinance writ large. And so here, I think a key aspect of plaintiff standing must be linked to injuries caused by specific cell phone towers that are affecting their health in the ways that they allege.
Well, aren't they alleging they also have an injury by not being able to speak to the issue of the environmental effects of these towers at all during the process of locating them? So
two responses to that. The first is, I think that runs right into sort of what was going on in Clapper, where that's a sort of chilling type injury where they're saying, we don't want to speak at these sorts of hearings out of fear that things we say will eventually be used by telecommunications companies if a citing application is denied. And again, Clapper...
I think their argument's a little different. I think their argument is we want to be able to argue so that it can be considered, and they won't even consider this issue. So turning, I'm just out of time here. I have to turn things over to the city, but just to respond to that last question, I think even putting aside, even if this court was to find that there was standing on that sort of theory that merely arguing that you would like, and again, I highlight that plaintiffs have made very clear in their complaint that they have in fact spoken about these issues consistently for the past 15, 20 years. So this isn't a case where they're saying that they were actually chilled. But even accepting the point that the mere fact that they would like a specific government
state or local government to make decisions based on these health concerns, it was enough to get past standing. I think you still have the sovereign immunity issue, which I think is just a plain statutory text issue. And then I would just finally say that the district court, if this court were to reach the merits, the district court correctly dismissed all of these claims on the merits because there is no constitutional deficiency in this statute. And I'm over time, and I don't want to step too much on my co-defendant's time. So unless there are further questions, I'll turn things over to the city.
Thank you.
All right.
Marcos Martinez for the City of Santa Fe. May it please the court. The United States has articulated its position on the appellant's challenge to the Federal Telecommunications Act in general. The specific claims against the City of Santa Fe turn in large part on whether the appellants can maintain their claim that the Telecommunications Act is unconstitutional or not. Without belaboring the point.
Counsel, let me ask you this. If a citizen of Santa Fe goes before the city council or the appropriate zoning agency and expresses an objection to the placement of a tower under the facts asserted in this complaint, can the city consider those protests in making its citing decision?
No, it cannot because of the statute, 47 USC 332. The statute clearly prohibits the city from considering the health effects of RF emissions in its zoning decisions.
Yes. And does the city interpret environmental considerations under 704 to include health considerations?
Yes, we do. We follow the guidance of the FCC in interpreting that term. The FCC is the agency which Congress has delegated the authority to regulate or further administer the Telecommunications Act. And so we find that guidance to be both persuasive and controlling on the city.
What guidance specifically?
In our brief, we cite on page 21 of the city's response brief, I note that the FCC has offered guidance for what an environmental effect is. It states that state and local governments are broadly preempted from regulating the operation of personal wireless service facilities based on RF emission considerations. Thus, for example, a local government may not require a facility to comply with RF emissions or exposure limits that are stricter than those set forth in the Commission's rules. And it may not restrict how a facility authorized by the Commission may operate based on RF emissions or any other cause. We note that the Commission's plenary authority in this area has recently been upheld by the courts. Unfortunately,
Counsel, is there a meaningful distinction between the city's inability to consider environmental effects because of Section 704 on the one hand, and whether a citizen can at least present arguments at a hearing about environmental effects? In other words, if a citizen comes in and says, I'd like to talk about environmental effects, is the city council going to shut that person down?
Your Honor, no, the city council is not going to shut that person down, and the city council has not shut the appellants down in any of the cases which they've presented information. I view the 47 USC 332 as basically carving out certain subject matter jurisdiction areas for the city to regulate within. So we can regulate the zoning, we just cannot consider, because Congress has pulled it out of the city's authority, has preempted the city from considering the health effects. And from the city's perspective, there's an important reason for that. The city is not an expert on RF emissions. We cannot hire and determine what a safe level of RF emissions are. And we wouldn't want to duplicate the efforts of creating a mini FCC in the city of Santa Fe and then have a different standard for RF exposure in the city of Albuquerque, the city of Denver. I realize my time is up, and I thank this court for an opportunity to speak. I'll stand for any questions should you have any.
Well, I have a question. That is,
Judge Lucero, we can't hear you.
okay, is that better? Can you hear me now?
Yes.
Yes, Your Honor.
I said I have a problem which is akin to a due process consideration. That would be akin in a case for a court to say, well, Mr. Witness, yes, we're going to hear you, but we're not going to pay any attention to what you say. And that clause, we're not going to pay any attention to what you say, cannot be said to be harmless. And in the context of a city saying we're going to listen to our citizens to protest all they want, but we're not going to pay any attention to what they say because the law doesn't allow us to do so, cannot be said not to present an injury. I mean, the case may not have merit for 100 reasons, but that's not one of them, it seems to me, to say that people have the right to protest and to pretend that it's going to have any consequences is just nonsense.
Well, Your Honor, in response to that, I would say that presumes that the appellants have a due process right in being able to articulate an objection to the location of a particular cell phone antenna. And it's not clear to me under the facts pled in this case that they have any such protectable interest. You know, the due process clause.
Don't they under the ordinances and regulations of the Santa Fe proceedings, don't the citizens have the right to appear and be heard?
The code gives a list of entities that have the actual standing to protest land use decisions. I don't know that these particular appellants have pled facts that establish that. With respect to the notice and the right to be heard, again, notice and right to be heard is in conjunction with a constitutionally recognized right to property, liberty, or life. And I don't know that they've established that.
All right, well, we'll have to look at the pleadings and see if they do. Thank you, counsel. Anything further in this case? Did the appellants have some time remaining?
Judge Lucero, I think we still haven't heard from Mr. Bell for the state.
Oh, okay. I'm sorry. Thank you, Judge Matheson, for picking up for me there. It's hard to not be able to see the proceedings. Go ahead, please.
Thank you, Your Honor. And if I may, I'll be brief. Neil Bell on behalf of New Mexico Attorney General Hector Balderas. And in addition to the arguments raised in the briefing, I just want to emphasize that if the court affirms dismissal of plaintiff's challenges to Section 704, it should also affirm dismissal of plaintiff's challenges to the state and local laws at issue in this case. And that's because the preemptive effect of Section 704 is really the threshold issue for all of the claims here. All of plaintiff's claims are based on their arguments about the alleged environmental effects of RF emissions. But as the district court repeatedly emphasized, Section 704 prohibits the state and the city from considering those effects when it comes to citing smaller personal wireless facilities. So in effect, the state and local laws here are really acting as pass-throughs for the purposes of plaintiff's claims for their challenge to Section 704. So if the court affirms the dismissal of plaintiff's challenges to Section 704, there's really nothing to litigate in terms of the state and local laws. The other thing I'd like to emphasize is plaintiffs have cited no authority to say that the state lacks the authority to provide a forum at the state level for challenging the siting of these locations generally. the state, for rational economic reasons, decided to encourage the development of wireless facilities through the passage of the WCAIIA. And to the extent that any individual property owner wants to challenge the provisions of that statute, they have the forum of approaching their legislator and asking for amendments or appearing at any legislative hearings that may come up in the future on that issue. So at the end of the day, I think that really this appeal rises and falls with the viability of plaintiff's claims challenging Section 704. Thank you.
Thank you. Thank you, Councilman. Judge Mathis, is there any time remaining on the appellant side?
No, sir.
Unless we've allowed the appellees to go over, if we wanted to, we could give her a couple.
We should extend, if they have gone over through our questions, we should extend the same courtesy to the appellant. So why don't we? Are you both in agreement to grant 3 minutes additional time?
Yes.
Yes.
All right.
Thank you.
Fine. Thank you. You're welcome.
Thank you. Yes, in relationship to the questions about how the petitioners or the appellants would be able to argue in front of whatever entity is going to approve or deny the placement of an antenna or a tower. I think this court's analysis is correct. It is akin to you bringing a witness into the court and saying, speak as much as you want, but we have our ears covered. And I think that everyone is very much aware of the FCC's preemptive powers and their willingness to make sure that everyone knows that they are considered the end-all be-all, and there better not be a hint of discussion of environmental effects in any of the supporting papers that go up on.
But that being your argument, why do we need, or why do you need all these remaining parties? Why isn't this case really strictly a case about whether 704 is constitutional? And whether your claim survives under 12b-6, given that challenge?
It is possible that the state and the local government, Santa Fe, would not need to be added, except that they are participants in already following Section 704. So the harm that they've already done is at issue here as well.
But isn't, I mean, focusing for a minute on your substantive due process claim, didn't you have to name the FCC? I mean, isn't that the party that your beef is with?
No. I don't think we had to name the FCC, and there is a case that was just recently decided in the Ninth Circuit, the Northern District of California, Cohen v. Apple, in which the FCC was joined by the court, and the FCC made it very clear that they were not a party to the action, and that any argument otherwise would be futile. So I think that really we're looking at the definition of environmental effects, and we're looking at the impact that has on everything else. And my time is done. I'm so sorry. Thank you so much. I'll stand for more questions if you have them. Otherwise, I thank the court for their time and convenience.
We thank counsel. Counsel are excused. The case is submitted. That concludes the arguments this morning. We have a case arguments again tomorrow morning at and the